All right, all you future barristers, welcome to The Explainer. Listen, if you're gearing up for the Queensland Bar exam, you've definitely come to the right place. Because today, we're breaking down a principle of evidence that can literally make or break your case. We're talking about retrospectant evidence and its, let's say, very powerful cousin, the presumption of regularity. So here's the plan for this explainer. First up, we're going to figure out how you can prove something happened in the past just by looking at the aftermath. Then we'll check out this idea in action with some really classic examples. From there, we'll jump into the big one, the presumption of regularity. And we'll wrap up by looking at the crucial limits that you have got to know for your exams. All right, section 1. So, in court, you don't always have a smoking gun, right? You don't always have that direct piece of evidence. So how do you prove something that's already happened? Well, that's exactly what this is about. It's the art of inferring what was by looking at what came after. You're basically reasoning backwards from the aftermath. Okay, let me throw a classic legal puzzle at you, because it really sets the stage perfectly. Picture this. A ship sets sail, and just a little while later, it sinks. And get this, the waters were calm. The owner is adamant, swearing it was in pristine condition when it left port. So, here's the question for you. How in the world do you prove it was unseaworthy before it even sailed when all your direct evidence is sitting at the bottom of the ocean? And the answer is this really neat concept called retrospectant evidence. The logic here is actually pretty simple, but it's incredibly powerful. It says that a later event can justify an inference that a certain state of affairs or even a state of mind existed before that event. It's like the subsequent event is a giant arrow pointing backwards in time. It lets us piece together the past based on what courts call the ordinary laws of reasoning in human affairs. Pretty cool, right? So, okay, that's the theory. But how does this whole thing actually play out in a courtroom? Let's look at the evidence in action. We're going to see this principle come to life with some really interesting real-world legal scenarios.
And here it is, the answer to our puzzle. The fact that the ship sank so quickly after leaving port, with no other obvious cause like a massive storm, that right there is compelling evidence. A court is allowed to infer that it must have been unseaworthy when it left. Basically, the disastrous result points directly back to a flawed beginning.
Now, this same idea works in criminal law, too. So let's say the police find a loaded rifle in a suspect's car 3.5 hours after a crime was committed. That's a powerful find, right? Because it strongly supports the inference that the rifle was also loaded at the time of the offense. The court can infer that the state of being loaded continued backward in time. Okay. Here's another really potent example that's based on what the courts call the ordinary course of human affairs. Think about it. If a woman takes a morning after pill, well, given the specific purpose of that pill, the act of taking it becomes pretty strong circumstantial evidence. It suggests that the event that would make it necessary, in this case sexual intercourse, happened shortly before. The action itself points directly to the event that preceded it. And honestly, once you start looking for this, you see this principle everywhere. A driver caught doing a crazy speed, it suggests they were speeding just moments before. Someone produces an endorsed check that they wrote themselves, that's pretty solid evidence that payment was actually made. An employee who never once claims they're owed back pay, the inference is that no salary was actually due. And in contract law, this is a big one, a defect that shows up right after you buy something. You can use that to infer the defect was there at the time of the sale. It's all over the place. Okay, so we've got the general idea of looking backwards down, right? Now let's level up. We're going to move to its most powerful, most formal application. Seriously, for your exams, this is a total must-know. It's a very specific and very potent type of this reasoning, and it's called the presumption of regularity. And right at the core of this whole presumption is a Latin maxim, and you absolutely 100% need to have this memorized. So let's just let it sit there for a second. Omnia presumuntur rate its illuminate esse acta. This is the absolute bedrock of the principle. So yeah, commit that one to memory. So what does that all mean? Well, simply put, it translates to all acts are presumed to have been done rightly and regularly. Now, it's a rebuttable presumption, which is key. That just means you can challenge it if you have evidence to the contrary. But the starting point is that we assume official and formal acts were done by the book. There's a famous judicial quote that puts it perfectly. The wheels of business will not go round unless it is assumed that that is an order which appears to be an order. It's all about making the courts run efficiently.
So where does this thing actually apply? Well, think public and official acts. For instance, you see someone acting as a police officer. The court presumes they were duly appointed. You don't have to waste time proving it in every single case. A company that's up and running and trading, presumed to be properly incorporated. A local council that has a statutory duty. The law presumes they've done it correctly. Even the speed limit signs you see on the side of the road, they're presumed to be valid and put there by the proper authority.
And listen up, because this is where you're going to win the big marks on your exam. You have to know the limits. This presumption is not a blank check. It's not a free-for-all. For a sharp barrister, understanding where this presumption stops is just as important as knowing where it applies.
Okay, the biggest, most critical distinction you have to get your head around is public versus private. The presumption applies really strongly to public acts, right? The due appointment of an officer, a council making a statutory decision, that kind of thing. But it hits a brick wall when it comes to private matters. So, for example, you can presume a solicitor is qualified, but you can't use this maxim to prove that they were retained by one specific private client. That's a private contract, a private arrangement, and it always needs its own direct proof.
And when we get into criminal law, the limits get even stricter. You have to be so careful here. The presumption can absolutely not be used to prove a fact that is central to the offense itself. The Crown can't just use this as a shortcut to skip a step in their proof. And it shouldn't be used to presume something that goes against a person's liberty, like just assuming a prisoner is being held lawfully. And here's the classic example you'll see. You cannot presume a breathalyzer is the official, statutorily approved type just because the police have it. The prosecution has to stand up and prove that specific fact. So let's boil all of this down into your exam essentials. Here are the 4 things you need to walk away with. Number 1, master the core definition of retrospective evidence. Really get it. Number 2, memorize the omnia maxim. Know the Latin, know the English translation. Number 3, absolutely nail that crucial distinction between public acts, where it applies, and private acts, where it doesn't. And finally, number 4, know those critical criminal law exceptions inside and out, especially the ones about core facts and liberty. You do those 4 things, you've mastered this topic.
And I want to leave you with one final thought to chew on. This is an ancient presumption, right? We rely on it for efficiency. But think about our world today. It's run by complex digital records, by automated systems, by algorithms. So when does this incredibly useful presumption that things were done rightly risk becoming a shield? A shield for hidden errors, for bugs in the code, or even for outright misconduct? That's a really critical question for you, the next generation of barristers, to grapple with. Thanks for joining us on The Explainer.